Now, good evening. This is Laws 11057, Introduction to Law. It's week number 8. It's the first week that we're dealing with legal research, and it's also feedback week. I'm very keen to get your comments and thoughts in relation to the course so far, but very importantly, to have your opportunity to ask me questions about assessment and also to clarify in issues in that regard. So as I posted on site, it's your opportunity to discuss problems that you might encounter, issues that are of concern, things that you'd like to discuss. I'm very keen to receive feedback and very keen to ensure that your assessment requirements are well known to you in advance. I'm keen for you to tell me about the course. Are you gaining the knowledge and skills that you'd hope to obtain? And it's a matter of perceptions and participation. I am concerned that some are not participating to the degree that I would like to see. And tell me if I'm expecting too much in that regard. Also, tell me, are you happy with the assessment regime? What needs to change? Now, I should say that you will have your opportunity to formally and anonymously have your say over the coming weeks. So this is really an opportunity to ask for clarification or give me some guidelines as to what you'd like to see for the rest of the course. So can I open that up? And you can feel free to ask these questions on the chat facility, and if you like, I won't announce who is asking me. So one question is it normal to sometimes feel overwhelmed, also to feel like we have to achieve a perfect grade? I love the course so far. Well, I like that last comment. Absolutely normal to feel overwhelmed. And if you're going to practice in law, all I can say is, and I don't mean this as a negative comment, but as a reality check, that you need to get used to that and you need to create some coping mechanisms to do it. We had our really good discussion, I think, on resilience and talked about some of the issues that you need to be aware of in terms of your health, your mental well-being, your outlook on life, and the course generally. We've talked about some of the coping mechanisms in terms of time management. You'll need to try and implement that and make your own ways of doing things. I may have mentioned to you that even from a young age, people have always thought about me as being a little OCD and having some funny habits. One, for example, is that I absolutely follow a clean desk policy. I might have material piled up on the desk behind me, but the desk that I work from, where my computer is only will ever have the file that I'm working on. Very often I will put my phone on Do Not Disturb. Quite often I won't be answering emails while I'm working on a project. So once I've finished that task, perhaps drafting some documentation, then I'll check my emails. I usually have all my pens and rulers and things in the same spot. I have habits at work so that if, for example, you saw my office now, if once you knew the layout of my office, you'd know where the files for court tomorrow and court the next day and court the day after are kept. You'll know where the files are kept in different orders. And also, if you saw the layout of my files, you'll see that I have the client instruction sheet maintained in a very similar, consistent way throughout all the files, and I go to the trouble of thinking about what I need on a file and then preparing my own little instruction sheets to go with it. So these are all sorts of coping mechanisms where what you're doing is you're planning, ready to go, knowing that you're going to be under pressure. You can rely upon sensible habits and sensible routines to get you through. I probably all told you about the keys in the fridge philosophy that I adopt. Now, are you looking at me quizzically when I say keys in the fridge? I probably haven't told you that yet. Now, why would I, as a solicitor, want to keep my keys in the fridge? Not all the time, only sometimes. Anyone like Melissa has got it? Absolutely. The milk. And why do I want it? And why? No, not because that's where the beer is. Because the milk is there. And why is it so important that I put the keys in the fridge? Because I want to remember the milk. Can anyone offer a guess? Don't forget the lunch, coffee. No. They're all good reasons, but not the reason. Why do I keep the keys in the fridge so I get the... Exactly, Melissa's got it again, the wife. So if I get a call saying, don't forget the milk, what do? The very first thing I do, I put the keys in the fridge so that I will walk in proudly saying, here is the milk as you asked me to bring home. Now, why am I telling you this in a law subject? Well, the fact is it's really important, and I'm not joking, because what you need to do is keep down your stress levels, adopt a do-it-now attitude, and make sure that you have safeguards in place so that those things that you want to do and you want to do well and you want to ensure that people are, that are relying upon you can feel safe that you're doing the best job. You're setting up these safeguards and you're setting up these procedures. So when I go to court tomorrow, I want to know that the 8 files that I'm working on are all there. And even though I'm hurried and it's 5 to 9 and I've got to grab the files and go, I'll know that because of my routine, all of the files that I need are in the one spot and I don't have to second guess myself and risk being late for court. And I know that when I open the file, I'll be able to present the best job I can for the court because I have a routine. I know that certain things that I need to discuss in the court will be contained in a certain part of the file. So it's all establishing those routines and adopting a do-it-now attitude. Let's hope that no one steals the fridge. Yes, that's true. Okay, so they're some of the real practical issues that you need to consider. Now, in your examination, you can quite possibly expect a question about what you're going to do from a practical perspective to prepare for, let's say, court. Now, I apologise again that most of my emphasis is on court because that's what I do every day. But I want you to start thinking about, from a practical point of view, what are you going to do? What are the safeguards? And so in that sense, it may not be a question about the law. It might be a question about your good habits and developing those habits. And you need to do all that as you're studying as well. Now, I think I started all this from the perspective of how do you cope dealing with feeling overwhelmed? Well, there's some of the techniques that I use. And of course, you've got to keep your physical fitness and a sense of humour. Also, just remember, of course, that, and this is the beauty of law, just keep thinking about this, there is not necessarily going to be a right or wrong answer. It's just a case of mounting an argument and presenting something to the court which is logical. It's up to the court to decide if you're right or wrong or not. And if you have 7 High Court judges and they decide 4-3, well, that doesn't mean that the 3 that got it wrong don't know any law. Quite the opposite. It's just that their colleagues chose to decide matters differently based on the same factual circumstances. So there's nothing wrong with running a case and coming second, as we say. So barristers will often say that a silver medal isn't necessarily a failure. All right. So that's how I think we cope. And it's all right to be overwhelmed with the course. Oh, another thing that I'll mention from a practical point of view is this. Not so much in this course because, believe it or not, there's not that much reading in this course, not Introduction to Law. But you will get some courses where there's an enormous amount of reading. Say, for example, I'm looking at my environmental law books and one of the texts is about 900 pages and it's a lot of detail in it. So how do you cope when you've got that much material to get through? Well, a very practical thing is that I use one of these highlighters. And as I highlight, as I'm reading, I highlight, but I highlight very selectively. And a paragraph, which might be, 200 words, might end up being the subject of highlighting of 20 words. But I make sure that those 20 words can be read as a sentence, so that when I'm going back and reviewing my work and reviewing that paragraph, I can read the 20 words that I've highlighted and it will make sense as a standalone sentence within itself, so that I can get the gist of what's in that paragraph by reading. If you just highlight words, that's okay, but sometimes it won't make sense with a quick reading, with a glance through reading, and you may have to spend time to reread the paragraph. So the idea of the highlighting selectively to make a sentence that's readable in itself is so you can quickly glance at that paragraph and move on. That might be particularly relevant if you're dealing with open book examination situations. So that's just another practical tip. All right, so it's okay to be overwhelmed. It's okay to feel under pressure, but enjoy it and go with it. And just remember, of course, everyone's going to be in the same boat. All right, any other feedback? Does anyone want to tell me about the assessment regime? You can do this anonymously. You can put it on the chat line. So the assessment regime, useful, silly, not enough. You need more assessment. You'd rather more assessments and less exams, more exams. Fine is the first comment. So the idea of the assessment, of course, is that the first assessment piece is to do with case law. The second assessment piece is to do with legislation. If we're doing introduction to law, it makes sense that we have you comment upon the primary pieces of the sources of law first. And then the third assessment is your reflections upon this whole thing. Feedback helpful, insightful. Too many uni sites to log on to. Yes, there are a lot of uni sites. And of course, we do have Moodle and UCrew. And I appreciate that's distracting in a way. You've also got staff mail for me. You've got student email to log on to as well. And then, of course, what we then direct you to a whole lot of other sites. So you've got the legal research sites, and I'm very keen to get your thoughts in relation to the legal research that you've been doing through the university sites, Ostly, etc. So there's a whole lot of places where you need to go. In a way, that's not necessarily a bad thing because you'll need to get used to that in practice. All right, so assessments, I'm gleaning that generally we're happy with that. Feedback, I'd prefer a bit more feedback about what I could have done better. Positive comments are great and encouraging, but I'd like to do better. Yeah, I'll try and give as much personalised feedback as I can, but of course I then supplement that with the more general feedback to the class. I'll take that on board and provide as much feedback as I possibly can. Legal research book, a shocker being out of date. Yeah, and I apologise in relation to that. This is the second edition. I'm using it at the moment, but I do have the third edition sitting on my desk, so it has been superseded, and it was just a timing issue. The third edition came out just too late for us. I'm sorry. All right, so Zoom, is everyone generally happy with Zoom sessions as a way of interacting on a weekly basis? And is it, so that's a yes. Zoom is great, yes. All right, I think Zoom is very good. I did use Collaborate for a little while, but I prefer Zoom. Okay, but if you find it's difficult, let me know. It may be that some of you need an audio-only version of Zoom. So let me know if that's the case. All right. Is there somewhere you can get legal information in voice format? Okay, so you can listen to in the car or while walking. That's a really good idea. We have the podcasts, which Wayne Jones has prepared, but let me see if I'm clever enough to try to upload an audio-only version of our weekly sessions. I'll try to do that. All right, so we've discussed the Zoom, we've discussed the format, we've touched upon the textbook. I'm a real fan of the New Lawyer. Any comments about the New Lawyer? Any thoughts on that one? Even though I think it's very good, I'm open to criticism. Yes, New Lawyer is great text, surprisingly easy to read. It's good.
John, just with that one,
yes.
As you know, I sent you an email at the start of the course. I actually purchased that New Lawyer as an ebook before I even started the course. And I find the use of it on the iPad is really good in bed at night because it lights up. The problem is it seems like we're, I guess, encouraged by doing this course by distance in the first place to go electronic. I was disappointed to see that, obviously, because it's internet capability, we then can't use those books we bought in the exam.
Oh, that's a really good point. So you've got no access to the new lawyer unless you print the relevant chapters.
No, I bought it. I now own 2 copies of it because I bought the hard print because of the exam thing. It was just that, the whole course is by a distance. We do everything on a computer. You even have an app for it on the iPad. But yet, come exam time, we lose its functionality and we can't use the tools we've been using all semester.
Yeah.
My last uni course was like that too.
Oh, was it, Kirthi? Yeah. Look, I think that's a really...
the textbooks are always electronic.
Okay. And how did you get around that with the exam, Kirthi? Was it a case of you couldn't use the electronic version in the exam?
I was studying from PNG, so they made an exception that I could take my laptop into the room. I didn't have connectivity. I just had to show that I couldn't connect to the internet.
Oh, I see. So you were able to take your device, your laptop in, but it was on the hard drive and you just weren't able to access the internet.
Yeah, that's right.
All right. Look, and I'm getting a note up here saying, why can't computers be used? Just remove access to the internet. Simple. That sounds like a really good idea. And you're right. I agree with all those comments. It's an e-course, and here we are not allowing you to do that in the exam. You can understand.
Print cartridges are very expensive.
Yeah. And you can understand, of course, that I'm in no position to make any of these decisions, but I am in a position where I can at least make comment for people that are on a much higher scale than me to actually make decisions. All right. Remove internet. And I'm just making a note in terms of podcast of Zoom sessions. Okay. Any other issues in terms of the materials? Okay. UCrew, any thoughts? What's the general consensus with UCrew? Are we happy?
John, it's Robin.
Yes, Robin.
I actually really like UCrew. I didn't think I was going to, but I think everybody knows how much I love it.
Okay.
I think one thing that I am disappointed with is that there is not as many people participating in it as I would have liked, because I just see it as being an exceptional learning tool, personally. To be able to throw up a question and have lots and lots and lots of people make comments or contribute is really helpful from a learning perspective. And I find that my learning is limited because people are not contributing.
Yes, okay. Thank you very much, Robin. I'm a real fan of it as well. As you know, it's an introductory. It's one where UCrew is just being introduced as a tool, possibly for future use. I'm not sure that my colleagues are all in agreement with me that it's good. And we're getting comments in from others saying, no, it sucks and I don't like it. So certainly the jury is out, so to speak, on UCrew. I happen to really like it, but certainly I'm aware that other course coordinators are not happy with it. So I'm interested for your thoughts generally. And thank you, Robin. Thank you for those.
But can I just say something on that, John? Even if people don't like UCrew, there's still limited participation on Moodle as well. And when I first started the course, I thought, all right, maybe I should go over to Moodle and see what's happening over there. And there was really limited participation there too. Yes. So it's actually that limited that I have actually considered over the last few weeks whether I should be doing a contact course. So actually attending university and working with other people, because I'm just not getting that level of working with others. Yep. So I find that the study group is exceptional. Having a study group a couple of times a week with my colleagues is awesome.
Okay.
This whole online thing just doesn't seem to be that great, really.
Not working for you. Well, I'm pleased to hear the study groups are working. Certainly, and again, back in the 70s when I was studying law, the formal contact was in the course of a lecture, which was typically 1 hour per week, and then 1 hour tutorials. So the formal contact was about 2 hours per week, but of course I would spend my days, as most of my fellow students would do, at the university library. So there was that face-to-face contact with fellow students pretty much all the time. But of course we didn't have the internet, we didn't have any resources electronically at all at that stage, so you really had to be at the library so you could access the books. But it did make it easy to speak with people. So some of the comments coming in terms of study groups, I like the idea of a study group. I think it's a really good idea. It's probably something that I should foster more at the start to encourage people into study groups from what you're saying. One of the hard part, of course, is to try and organise the study groups, which we leave to you to do. Some comments in terms of the UCrew, lacks on low-end hardware, user interface is badly designed, sundry authentication errors are always fun. I like it. It's better than smoke signals. Each to their own. It's a bit like Facebook, can be a time waster, depends on circumstances. And I'm not a Facebook user, I've never used it, but they tell me that it's a little like Facebook, so I understand those comments. All right, what about Moodle? Is everyone happy with Moodle? Is it generally we prefer Moodle or we prefer UCrew? I would say from the volume that UCrew is probably about, I would say there's about 9 posts on UCrew for every 1 post on Moodle. Moodle preferred. Nothing like Facebook. And I'll accept all that because I don't know Facebook. It's fine once you know your way around. Moodle seems to get to the point. Moodle is good too. All right, so I think we're saying Moodle's not bad in any way, but they're maybe just different, and people have different preferences. Okay. Now, are there any other questions about the assessment, about the exam? Do you all understand what's required of you in the exam? Any issues there? Good. Okay. Now, let me make some comments in relation to presentation. You've probably been surprised, I suspect, at the degree that I've been harping on about presentation. And please feel free to give me your comments in that regard. Here's what I want to achieve. I want to achieve a situation where every one of you studying this course will be well regarded by the course coordinators that follow me. I want them to be almost taken aback with the level of presentation. Presentation is really important. When I'm looking at a document which has been prepared, let's say by a barrister, if it's presented professionally, and typically they are, but if it's presented professionally, if it's well laid out, if I can't see any obvious errors on the face of the document, I'm immediately encouraged and I'm immediately comforted by the fact that this person appears to know what they're talking about. But maybe it's just me, but I can pick up a document and my eyes are immediately drawn to the mistakes and the errors. Maybe it's just habit, I don't know. And then I start to lose confidence. So having it well laid out is really important for that initial feeling with it. It's also important because if you can get certain things right, it means that you are part of the club. What do I mean by that? If, for example, you type the name of a case and you don't put it in italics, it says to me you don't really know how to do this. You haven't read enough of legal writing and you haven't written enough legal writing to know that the name of a case has to be in italics. So put it in italics. If you don't reference using footnotes, it tells me that you're really not a law student or a law practitioner, because that's what we do. In terms of setting out, even though there's been some comment about this book, just have a look at the way in which the book is laid out. It's beautifully simple. It's in a modern font, and I know that some of you would probably disagree with my adverse comments about Times New Roman, but it's a little old-fashioned. The headings are simple. They're not in your face. You don't see headings that are in bold and capitalized and underlined and very, very busy. So it's a little subtle. So that book is a really good guide to the way in which things should be set out. It includes some figures and some tables, which is always great. And you'll see the way it's footnoted, and you'll see the way that case is referred to and the legislation is referred to. So if you want a simple guide, just have a look at that. And that's typical of much of modern legal writing. So that's what I want you to achieve at the end of the day. So there's a few things. You'll notice that book, as in most legal writing, is it's paginated. It's got a page number. I prefer to see double spaces between sentences. That's what you see most of the time. It just means that your eyes aren't challenged as much. It's a little easier to read. Legislation should be in italics. When referring to legislation, type the name of the litigants in italics. The year in citation is not in italics. When referring to legislation, capitalize the word A in the word Act. When quoting legislation, don't quote the internet source such as Ostley. Refer to the case itself. So Humsey Hancock, re, square brackets 2007 QSC 34. That's what we want to see in the paperwork. We don't want to see the internet link. Legislation, prefer specifically to the legislation, for example, the Legal Profession Act, rather than referring to the link to a generic website such as www.legislation.qld.gov.au. Take care with your grammar. It's very simple. Just in Word, you've seen all those red squiggly lines and green squiggly lines. Well, make sure that you consider those and make sure that you deal with them. Now, I don't mind if you delete them. You can right-click and you can get rid of them. So before you present your paper to me, if you want to hide any possible spelling or grammar issues, just delete the red and the green. But what I'd prefer is that they're deleted because you've actually fixed it up. And you'd be surprised the number of times where there have been misspellings and inappropriate grammar. Now, having said that, assessment number 2 was miles in front of assessment number 1 in terms of all these basics. Avoid legalese. I don't want to be saying things like here and after before or the said act, etc. So get rid of all that legalese, that old-fashioned legal talk. Be innovative, use flowcharts, for example. There were some terrific flowcharts in the second assessment for those of you who chose to put in flowcharts. And I think we're going to be seeing some on UCRUISE soon. Some other recommendations when quoting legislation, don't just simply refer to the Act, do more than that, and actually put in the section number. Having said that, you don't need to identify the part or the division of the Act, but really typically what you do is you see the section number of the legislation. So don't just put in Property Law Act 1974, put in section 74 of the Property Law Act if that's what you're referring to. When quoting material from other sources, use indented paragraphs, and that is, and then generally speaking, type it in italics. And just if you want some further tips, just go to my sample document. I take it you've all had a look at that document, and if not, you should do so. All right. How do flowcharts get used? Flowcharts could have been used and were very successfully used by some students in the first part of the second assessment piece. So where we were saying, look, tell us how you came across this legislation that you've made comment on, some students use flowcharts or screenshots and said, look, this is how I did it. And flowcharts can be great because your eye is drawn to that. You're also drawn to figures. I'll bet when you look at a page of legal writing, if there's a flowchart there, you're going to look at the flowchart first, probably before you read the text. So I think it's a really good way to do it. So yes, we don't want sloppy work. Just out of interest, how many barristers put out sloppy work? Not too many. Mostly they're all very modern in their approach, and their work is very good. What about case law? do we have to say the paragraph? Yes, in case law, mention the paragraph or the page, and that's usually pretty easy. But if you've got a 20-page case, and if you simply say, in this particular case, Justice whatever made this comment, do the reader a favour and let them know at least the page, or if not the paragraph. All right, so we've got some questions about handwriting in the exam. Yeah, look, people are always concerned about handwriting in exams. You don't have to be too neat. I don't want you to sacrifice the amount of words that you get on the page just for the purpose of being neat. I'm pretty robust about that, and I appreciate that a handwritten situation is entirely different to a normal situation where you get to type an assignment. So don't worry too much about that. Oh, write like a doctor. Well, that's a bit of a worry, but I'll cope with that as well. And chook scratch. Well, I can read chook scratch. That's fine. What does ex parte mean? Ex parte means in the absence of a party or the party. It's Latin. We're trying to avoid the Latin, but I think I meant the comment that having a bit of Latin means that, you know, other lawyers who don't practice in the field think that it must be very difficult work, what you do, because there's some Latin in it. And I'm being only half facetious there. And someone said that they've got really bad handwriting. So don't worry too much about the handwriting. All right, well, let's move on. I just want to now talk briefly about legal research. The text, I think, albeit that there was a comment about it being old-fashioned, or a bit out of date rather, is really very user-friendly, and it's a tough subject. Can I say that when it comes to legal research, I do use LexisNexis. That's simply what we chose at the office, and we're not a big firm, so we don't have the resources where we can afford to get Thomson Reuters and LexisNexis and everything else. So I'm not saying that LexisNexis is any better than Westlaw or Thomson Reuters. It's just the one we happen to choose. So that's why I'm more familiar with it. But when it comes to research, I generally will go to the primary source first and the secondary source second. And when it comes to the primary source, even though it's unauthorized, my preference is Ostly. I like the way that it's set out. So if I have a question which relates to a certain section or a certain act, I will then go to the act. I'll try to identify the relevant section, and typically I'll then read that section very carefully. And if I want case law on that section, the first thing that I do is go to the Note Up section of Ostly. And I see that Ostly has a new function called LawSite, but I go to Note Up. Now, does anyone know what Note Up is? Has anyone had troubles with that? If you go to Ostly, if you go to an act, if you go to a section of an act, have a look up the top and you'll see a thing called Note Up. Click that and you'll see a list of cases which relate to that particular act. Another thing that you can do is go to Jade Barnett, Jade Barnett, Barnett, and you can subscribe. So if you subscribe to Jade Barnett, you can identify areas of practice that are of interest to you, and you will get emailed to your phone or your iPad or your computer every day the cases which were decided in relation to that issue or that area of practice from the previous day. So that's a great way to impress, and I think I may have mentioned that before. All right, in terms of legal research, you can read the book as clearly and as intelligently as I can, so I won't repeat too much of it, but I'm going to highlight some points. Firstly, when it comes to legal research, there is the comment that for legal problem solving, they have identified the MIRAT program, or method, rather, MIRAT method. So identify the material facts. And that may be difficult unless you know the law to identify what is material and what is not material. Research may not be linear, so you may be going off on tangents from time to time. But do try to set out some sort of chronology or logical list. Now, here's the hard part. When it comes to an exam, there will be typically, not so much in Introduction to Law, but as you progress into the more substantive subjects, you'll be asked to solve or provide some advice in relation to a legal scenario. So you might be faced with a half a page or a page of text which outlines a legal problem. Now, in that, there will be the material facts. There will be a lot of red herrings. You understand what I mean by that? Things that are not material. You've got to decide what's material, what's not. And typically there will be things that are missing, or there will be an expectation that you make comment in relation to assumptions. So in the book, there was a comment about, well, here's what you have to do. John has been charged with driving with blood alcohol concentration of 0.06, advise. Well, you need to go a bit further than that and ask some questions that may be missing. Was John licensed? If so, what type of license did John have, etc. So there are some things where you should say that I'm working on the assumption that this is the case, or you can say in your exam that I need to identify by asking further questions other information that may be relevant to the case. So in a legal problem, you'll have material facts, you'll have immaterial facts or red herrings, and you'll have missing facts. And you've got to try and identify those three. But once you've identified what the material facts are, you then go to the next stage of identifying the legal issues. The legal issues, have a look for the key terms. Think about what is the area of practice. Are we talking criminal law, civil law, torts law? And sometimes there'll be more than one. Are we talking state law or federal law? Once we've done that, we identify and interpret the rules. We look at legislation and then case law. I go in that order. I look at legislation first. I then look to the case law. And it's a matter of trying to determine what are the binding precedents, what are the persuasive precedents, which are not necessarily binding. And that's a bit of an art to do that. If, for example, I set you an exercise, and I don't want to overload you with work, but if I set you an exercise of looking at note-up function in relation to a certain section, it's potential, two things may happen. There may be no cases at all in note-up, and you think, well, where do I go from here? Well, the second is there might be 20 cases, and you think, well, how do I work out which are the relevant cases? And sometimes, at least for me, it's a matter of relatively tediously, but as quickly as I can, moving through those cases to determine how relevant they might be. All right, so applying the rules to the facts, reasoning by analogy, which is talking about similarity between this case and your case, but also trying to identify what's similar to help you, but distinguish what's in that case between what's in your case and try to argue that to your advantage. So, for example, if you come across a case which indicates that for trafficking in methamphetamines, a particular defendant was sentenced to jail for 18 months, you might say, yes, but in that case, the defendant was 30 years of age with an extensive criminal history, whereas in my case, I'm acting for a 17-year-old with no criminal history at all, and that's an important distinguishing feature, even though that case, by analogy, should be applied in my case. So it's a matter of identifying what's similar, but also to distinguish your facts between the other facts. Do we need to argue both sides or only fast? Generally speaking, you need to identify both sides of the argument, but it may be that you're asked to comment from a particular perspective only. All right. Second sort of reasoning, inductive reasoning, which is where you broaden, you take a specific principle and then try to use that in a more general sense. The converse of that is deductive reasoning, where you're looking, narrowing, you're taking a broad principle and trying to narrow it to your circumstances. then arrive at a logical and supportable conclusion. So that's the MIRAT test. I'll leave you to read that in more detail from your text. I will just talk a little bit more about identifying or clarifying the legal issues, which is that second step in MIRAT. The example used in the text in Practical Guide to Legal Research is the family law issue involving child abduction, and that's a really good example because it brings into play not only family law but also some international law principles and the Hague Convention. So the suggestion by the authors in that case is that if you're asked to undertake that legal research, start generally, broadly, and then become more specific. Maybe consider a legal dictionary. Now, I tend not to, but if you're using a legal dictionary, either in paper form or electronically, then that's great. Then the legal encyclopedias, Halsbury's, which is the LexisNexis version, or Laws of Australia, which is Thomson Reuters. And then use Boolean connectors using the words and or not, etc. Have a look at table 2.1 on page 43, and that's a really good guide as to Boolean connectors. As I said, the way in which the authors in this instance have suggested you undertake your research is quite the opposite to what I've said I do, generally speaking, which is where I go straight to the legislation. But that's assuming, of course, that you're able to identify the legislation and you're prepared to take a punt. Now, why do I say prepared to take a punt? Well, it's this reason. If, for example, I'm faced with a case involving, let's say, trafficking in dangerous drugs, I'm going to take a punt and say that the important piece of legislation relevant to that case is the Drugs Misuse Act. I'll then go straight to the Drugs Misuse Act, straight to the section on trafficking, and I'll base my research around that. Now, what if I'm wrong? What if the Property Law Act is in fact the piece of legislation I should be looking at in determining what's an appropriate way to deal with trafficking in dangerous drugs? Well, clearly that's an absurd example because it never would be. But I think you get the point that I'm working on the assumption that I'm correct in going straight to the Drug Misuse Act. Maybe I should start more generally and undertake a search by saying drugs, trafficking, criminal prosecution, and as a result of that general search, presumably my inquiries will lead me to a specific section of the Drugs Misuse Act. Now, I've just gone straight to the Drugs Misuse Act, but just be careful that in doing that, you're not taking a risk of overlooking something which is very important. All right. So there's no way of searching a particular set of facts to find the relevant legislation and cases. Probably not. And part of the reason for that is that if you're looking at a certain factual scenario, there would be too much for it to link to a specific case. You need to be a little more specific. You need to identify some key terms and then go from there. All right, effective legal research. Work quickly but thoroughly. Now, that's all very well, but of course in practice or as a student, you're under pressures. If you're in practice in a law firm, you're under quite enormous pressure to get your work out in a timely fashion, and you're under billing pressure. In other words, the partner in your law firm is not necessarily going to be impressed when, at a weekly costs meeting, you say that you're only able to put 3 hours of work on the timesheets for the week because you were caught up undertaking some legal research and you wanted to ensure that you were completely thorough, but you didn't feel you could bill the client for that. The partner in the law firm might suggest to you that if you want to do that type of legal research, you do it on your own time. But while you're at work, you're expected to bill a certain number of hours per day. So you've got to work thoroughly and quickly, but you've also got to do it within the constraints of your practical constraints. Think laterally. People say, oh, law's not very creative, and that's where I totally disagree. We've had some good discussions on UCREW about all this. You can think laterally, and it's not necessarily going to be cut and dried. Look, just remember, of course, that while you're doing your studies, everything is compartmentalised. So if you're studying torts law negligence, then the question that's assigned to you is probably going to be to do with torts law negligence. But in practice, it's not going to be that neat, and no one is going to say to you, this client is coming in relation to a torts law negligence matter. They're just going to say, this client is coming to see you about a problem. So in identifying the problem and the solutions to the problem, you need to think laterally. You need to think expansively, and you need to think of different ways of resolving the issue. Now, from a legal point of view, that might mean that you concentrate on torts law negligence, fine, but it also might mean that you have to consider other things like criminal law, or maybe contract law, or maybe constitutional law. So just think laterally, think widely. Just on that point, you will be expected, before this course is finished, to be able to think laterally and not just about the law. There are other ways to deal with issues. Now, I teach, course coordinator for alternative dispute resolution. And in alternative dispute resolution, we deal with mediation, conciliation, arbitration, other forms of case conferencing, a whole range of different ways to deal with an issue and not just go to court. So that's my point. And even beyond ADR, what's wrong with just negotiating? What's wrong with writing a letter? How about you offer to meet someone and have a cup of tea or have a beer and try and resolve it that way? So the whole range of different ways that you can try to resolve something. So you can expect that I'll want you to challenge yourself and discuss how these things can be adopted in your practice, in practicing law down the track. All right, so thinking laterally, there's lots of room for creativity. In legal research, use double quotation marks around a term so that it can be recognised as a phrase. All right, and just final comments. Boolean search, table 2.1, I've mentioned that. Austlii note-up function, I've mentioned that. And Austlii has a new feature called LawSite, so check that out. All right, I'm sorry I've been talking a lot. I know it's been quick. There don't appear to be any questions coming up on the screen. Before I wrap up the session for tonight, are there any questions live or any questions coming through the chat facility? All right. Thank you very much for your participation tonight, and we'll see you next week.